Appeals of Tennessee is now in session.
Thank you, Madam Clerk. And to the lawyers, welcome to the Tennessee Court of Appeals. Your panel today consists of Judge Fryson, Judge Davis, and myself, Judge McClarity. You will present your case as if we were actually in a courtroom, except you will not need to stand when you make your presentation. And also, I would let you know, you're probably already aware of this, but I'll just say it anyway, that if any technical matters develop, please let us know immediately so they can be addressed. If there's nothing further, Madam Clerk, or will you please call this case?
Jason M. Peterson versus Jodi L. Carey.
Thank you. And for the appellant, are you ready to proceed?
We are, Your Honor. Frank Slaughter Jr. for Jason Peterson, Your Honor. And I was going to ask to reserve 5 minutes for rebuttal, but being from the Bristol's home fastest mile, or the fastest half mile in the world, it's probably going to be one of the fastest briefs too.
It's your time. You use it the way you want.
Yes, sir.
Right ahead. You may proceed.
Thank you, Your Honor. This involved a one-car accident, and my client was the passenger. Obviously, the driver operator was cited with a due care citation. The lawsuit was filed more than a year, but within 2 years, as provided under the statute 28-3-104. And therein, I also cite the Younger's case that basically provides, as the court dealt with the matter of first impression as to whether traffic citations are within the purview of the statute. And the Younger's court found that the statute was clear and unambiguous, applying its plain meaning, because the legislature, if they wanted to, otherwise but could have limited the scope of section 28-3-104A2 to exclude traffic citations, but did not do so. So accordingly, obviously by implication, the action was commenced by a law enforcement officer. In other words, we submit that this statute should apply for Mr. Peterson's cause of action.
Mr. Slaughter, is the actual citation in the record?
I do not see that it was in the record, no, Your Honor.
Then how can we determine whether it applies, whether the statute applies to this particular citation?
We had a joint stipulation was within our briefs. The appellee does agree that the citation did mirror the due care statute of TCA 55-8-136, which was the due care statute that was in the Younger's case. So taken from the what's accepted by the parties, we submit that the court can accept that as the actual charge.
I'm wondering, was this issue passed on by the trial court?
This issue came on a Rule 12 motion to dismiss.
Okay. The trial court did not make mention of this issue in their order of dismissal, though. Was there any reason why?
No, Your Honor, you're correct.
Okay. Okay, and you may proceed. I'm sorry.
Yes, Your Honor, and that's our case, Your Honor.
Counsel, was this a matter that came before the municipal court in Kingsport or in Sullivan County?
It was a city citation for the city Kingsport Municipal Court in Sullivan County. Yes, Your Honor.
So the Kingsport Municipal Court adjudicated the citation that was issued in the case, correct?
I believe it's either paid or adjudicated one way or the other, Your Honor. Yes, sir.
Very well. Thank you.
Yes, sir.
Carey, you ready to submit your time?
Yes, sir. I yield to Mr. Rose.
Ms. Rhodes? Yes, sir. You may present
Good
your case.
afternoon. Good afternoon, Your Honors. May it please the court. I am Kurt Rose of the Kingsport Bar Association. And you know, real quickly, I think in answer to some of the questions that have been presented to adversary counsel, I think that the issue did come up at the trial court about the 1 year statute versus the 2 year extension as referenced in the Younger case. And the issue that was discussed and debated in the court was whether or not it applies to civil fines, which is essentially what is at issue here. And it's from my research, as limited as it might be, I've not found a case on point dealing with a municipal citation. I think that the Younger case dealt with TCA code violation and was a first impression before this court on a traffic citation issue. It's been expanded here before you all today as to whether or not that expands to a civil fine, which is what the municipal code citation was. Mr. Peterson is here because Mr. Carey or Miss Carey was cited under 9862, which it mirrors TCA 55-8-136, the failure to exercise due care.
Are you all in agreement on that? Is there a stipulation that the language of 9862 is the same as the TCA due care statute?
It mirrors, Your Honor, with the exception of carrying no misdemeanor violations, because it is a civil fine capped at $50 under the jurisdiction of municipal courts.
So it's not a class whatever misdemeanor,
No,
or anything, like just a civil.
It's just a civil penalty, yes.
Okay.
And to answer Judge Frierson's question, it did not come before the municipal court for a hearing. I serve as a municipal judge for the city of Kingsport, and I believe this particular citation Mr. Carey received was paid. Otherwise, I wouldn't have been able to handle that case. It was never at issue in municipal court for the city of Kingsport.
That would have been a civil citation before
Correct.
the municipal court of Kingsport.
Correct.
Thank you.
And so that's the issue that we took up before Judge McClellan, was whether or not the 2 years is expanded for civil fines. And it was the argument of me on behalf of my client that it did not rise to that level, given the strict construction of the statute, the way the court interpreted the statute in the Younger case, strictly construing that language for criminal investigations, which that court in the Younger case, in the Younger case, took to apply when the officer issues the citation. But as this court will recall, since it was just 1 year ago, in interpreting that, a great deal was discussed within the court about the fact that carries the criminal offense. And I think that's the big difference here in the case before you all today, is that the citation issued to Jodi Carey did not carry any criminal ramifications. It was not a criminal procedure by any stretch of the imagination, both by the Tennessee Constitution, limiting municipal court jurisdictions to civil penalties only. There was no risk of a criminal investigation or criminal charges to the defendant in this case. And therefore, we submit that the 1 year statute should be applicable here, and it should not be extended to the 2 years. And that would be our case, and would be the defendant's submission before the court.
I'll say to you the same thing I said to the appellant attorney, is that my concern is that why the trial judge did not make mention of this, did not make a ruling on that issue.
I don't know, Your Honor, to answer that without the request by the plaintiff's attorney to get a specific ruling on that issue. I can't answer that. I know that's what we argued about. We argued both that, and we argued the COVID implications of plaintiff's counsel's office potentially being closed during and around the time that the statute would have lapsed. And to adversary counsel's credit, he did check his office calendar and did confirm to the court at the trial court level that his office was not closed around that time, which is then when the argument shifted to the extension of the 2-year statute of limitations. But I cannot answer for this court why Judge McClellan did not make a specific ruling on that issue.
Thank you very much, sir. You have your rebuttal, Mr. Slaughter?
Do Your Honor, because it reminds me of Rule 1 about speedy, just, inexpensive is how the rules are supposed to apply. And to speak to just, I know the law abhors the forfeiture, and this statute benefits Mr. Peterson. Ms. Carey still would have her day in court as well. And we'd ask Your Honor to go ahead and reverse the trial court. Thank you, Your Honor.
Thank you very much. Gentlemen, if there's nothing further, then we want to thank the attorneys for your presentation. We will take this case under review by this panel, and you will receive our opinion along with our judgment within a reasonable period of time. Thank you very much.
All right. We wish you all the best. Thank you very much.
Thank you all.
Madam Clerk, you may recess the court until the next docket.
The Honorable Court of Tennessee stands adjourned.
Thank you very much.